All right, here we go. This is Curt Varone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for September 23rd of 2024. Brad, go ahead.
First, before we get too far into anything, I want to just big shout out to all our new must-have policy subscribers. If you have not seen it, things are going great. Great comments back, great feedback. People can't believe how much they're getting for the low cost. So www.musthavepolicies.com, and you can see Curt my new product. But every day I get, almost every day I get really nice comments, and so kudos to you, and I guess me too.
It's a lot of work, man. It's been a lot of work, and it will continue to be a lot of work on our part. But it's a labor of love, as they say, right?
It's true. Somebody asked me, they said, well, how are the policies created? And I said, Curt's been doing this for 110 years. I've been doing it for about half that time. And I said, but the exciting part is, you and I are kind of merging our policies. So I'll have this idea, you'll have this idea. We put them together and we get like the best of all worlds. So I don't know. What people are getting for this value is insane. It is a great product and great value, and it is a lot of fun getting to work with you doing that. Okay, so if I had the ability right now, starting with our first blog post, if I had our ability, I would replay to a couple of months ago, and I'd be saying, I told you so, we're going to talk about the OSHA proposed Department of Labor standards. And here I am saying, I told you so. I said back then, everyone's overreacting. Everyone's getting a little crazy. People are getting nervous for no reason. They're talking about the demise of the fire service and the dinosaurs are going to roam the earth again. I mean, all these bad things. And so recently we had the Department of Labor came out. I'm going to read you a couple of the lines if you haven't seen them. And they basically said, you know what? We asked for comment. We got comment. We told you we had real questions, and that's what I'm going to focus on. And we now realize that this could be overburdensome. All or some, I think you're going to see just some of the regs are overburdensome on volunteer departments. And so we are contemplating, they haven't made a decision, contemplating what, if any, of the proposed regs should then be applicable to volunteer agencies. And the OSHA came out and said, we recognize that there are some states like New York that treat volunteers as employees under these OSHA standards, and they're incorporated then for not just career agencies, but volunteer agencies. So it'll be very interesting to see how they do this, because the part that I'm interested in is not career or volunteer, it's combination. And what is volunteer and what is too burdensome? Paid on call, right? 3/4 career, 1/4 volunteer. So like some New York departments and many other counties, Virginia, Maryland, who use combined systems. So all OSHA said is relax. We're looking at it. We'll see.
We're from the federal government. We're here to help you.
Yeah, exactly. But again, I think, look, I said this before. There was one line in OSHA's commenting rulemaking, and they said, I'm summarizing, but they meant it. We really want comment so we get to understand the volunteer career and the fire service. They really asked. And so I've said on this show a couple of times and a million other places, I really think OSHA is being sincere in wanting to understand the impact. I don't think all agencies always are, but in this case, I really do think they were sincere. And here you go as proof, right? They don't have to come out with this statement. There's no legal requirement for OSHA to have come out with this statement other than calm the heck down. Now, is it political is the question I'm asking. Was this at a timing where they don't want to upset all the volunteer agencies to come out against Biden? I don't know whether it's political or not. Remember, the head of OSHA is appointed, right, as executive, reports to the president of the United States. So I don't know whether it's political, but everyone should continue to relax.
Yeah, and I'll go back. I've had to respond to a couple of folks that have emailed me personally and a little bit in social media on this. And 2 points. One is that I don't think what OSHA did is all that burdensome, particularly for career departments. I really don't. I think most departments, maybe a little tweak, little bit here, a little bit there. Most career departments should not have if you do have a major issue, then
You have a major issue.
you've got a major issue and it's not OSHA.
Right.
Okay. But when it comes to volunteers, it will be a little bit more burdensome. But here's my point. And this is, I don't think government should be mandating things on an unfunded basis. That if government is going to come out, and here's my point. If government's going to come out and say, you have to do this, it is really, really important, then fine, fund it. Fund it. And then they're going to say, well, it's not all that important. Well, then if it's not all that important, because you don't, you're not going to pay for it, then why are you making us pay for it? Whether it's through taxpayer funds or bake sales or however else fire departments are being funded these days, chicken roasts and everything else. You've got to understand that there's a consequence to this. And if it's important, then it should be important enough for the federal government to fund it. And if it's not that important, well, then it's not that important. Make up your mind. But it can't be, this is really important and you have to fund it.
But it is. It can't be, but it is.
Well, that's my perspective on it. Okay, that really, I'm really opposed to unfunded mandates. I think that one way we can hold government in check is to say, fine, and I'm not disputing. If you think that something is so important that we need to enact a law to address it, fine, fund it. And then at that point you go, oh, well, and this goes back to another thing. It's a little pet peeve of mine, but when you are not doing, it is very easy for you to tell the person who's doing how to do it. Okay. And there's an inherent flaw in that. And not that people who are doing can't get better at it. Okay. But people who are not doing, telling the people who are doing what they need to do is a problem. It's a problem in the airline industry. It's a problem in medicine, and it's a problem in the fire service. And even to some extent, used to be's or never were's telling the doers how to do their job is a problem.
Yeah, and here we have, look, OSHA is there to protect the employee, right? That's the point of OSHA.
And mandate. That's right. And they can accomplish that by helping fund some stuff too, but that's a different story.
Yeah, which, but take firefighter physicals. The federal government's never going to fund it ever, a firefighter physical.
It's either that important, right? It's either that important, right, or it's not really that important. Right. But don't tell me I have to do something if it's not that important to you. It's important enough to you to tell me I have to do it, but it's not important enough for you to come up with the escarole here to pay for it.
I think the government has a motto, right? It's the Curt motto. It's, we won't fund, we'll find. We'd rather find than fund, right? Yeah, we're not going to do anything for you, but we will punish if you don't do it.
We know what's best for you, and you need to do this. And I'm not saying a lot of the things that they're saying are things we should be doing. I'm not saying that. But it's either so important that you go along with the funding on it, or you stay the F out of it.
Right. Now, all those feelings aside, OSHA is going to do what they do. They're going to have the unfunded mandates. Right. I think physicals are important. I would like it if we could get to a standard that's not as onerous as 1582, but somewhere that's reasonable. And look, I think the standard is very simple. We should determine whether the job performance requirements of any position can be safely undertaken by an individual. And the physical should be designed to determine that somebody can safely perform the job performance requirements.
Without violating other laws.
Right. And I think OSHA was going there because the regs proposed to creating job performance requirements, as we've done on our must-have policies, for each of the operational categories. What OSHA is doing, which I like, and we could stop after this, but is they recognize that the definition of firefighter does not just mean interior structural firefighter, that volunteers and others have drivers and, other exterior only, fire police, whatever.
Those are operators, and also depending on if you're in wildland, you have all these other things.
Exactly. So there's not one definition of firefighter. So this one size fits all regulation from what was it, the 60s or whenever the fire brigade standard was,
Yeah.
first out.
70s, yeah.
Right. So that, that doesn't fit. So at least OSHA's trying to become more modern. Maybe they shot for the moon and they'll, hit just orbit. But
again, I go back to on the career side. I think it's a pretty
right
reasonable
on.
standard,
Right. I agree with you.
On the volunteer, and then you get into the combination problem as well, where some of the people have to, but other people don't, and it's a problem.
Yeah. I just don't see how that's going to be defined. The standard now is allowed in all or nothing. But anyway, you and I could do this for hours. But in short, everyone relaxed, right? Relax. We'll see what's coming and who it's applicable to. Okay, let's go to Frederick County, Virginia.
Did you get a chance to read the complaint? I guess that's my first.
Oh my God, yes, and it's long.
It is. It's long, but just.
And here's the very short of it. But I read it, and I've got to ask you for something. Let me give you the basic facts to everybody. But we have an administrative assistant. The facts are like this, very easy to summarize for a radio show anyway. But an administrative assistant who works with the Virginia Frederick County government. Her son went through the academy, and she believed that the fire academy was a Marine style type boot camp, which was dangerous and over the top and inappropriate for a couple of reasons. She says it nearly killed her son in 22. And then what happens in 23 is somebody else has died at the academy. It was internally investigated. Apparently, no, we didn't do anything wrong, allegedly.
No, but allegedly the injury to her son and the death of the other firefighter were very similar factually, in that they were yelled at, and it was during physical training, and they were pushed and pushed and pushed and pushed. And with sort of, I'm sure that the instructors would say they were trying to motivate them and get them to understand their obligation to get themselves in shape. But we've talked on this show before about a thing called rhabdo, okay? And I forget how to pronounce it, the Latin part of it, but it has to do with when someone is pushed too far, they have muscle tissue breakdown that can cause the kidneys to fail, cause heart complications. We often used to think about this just as heat stress and heat stroke. This is, as we start to understand it, this is actually a little bit more severe. It's a severe form of this. But when someone is pushed day after day, or maybe only a couple of days if they're really pushed hard, but when they're pushed day after day after day after day, they don't get enough fluids, and their muscles start to break down, that there can be serious complications. And I talk about my brother, who was a drill instructor in the military. He went through 8 weeks of training before he became a drill instructor. And a lot of it was on this, that you can't push people that hard. And we have well-intentioned fire instructors that haven't had that kind of training, that think they can push people, and they're oblivious to this. And I've got some firsthand experience on cases and case studies where this has been happening.
We had this conversation, I don't know whether it was a year or 2 years ago, and I remember saying, look, I have fire instructor 1, I have fire instructor 2, I'm authorized to teach a bunch of state courses, and in my fire instructor 1 and 2 courses, they never once talked about, in any real form, other than, well, make sure they had their physical and make sure they're doing okay. But I mean, that's not, we don't talk about how we instruct. And there has been a big change. Let me get back to the case for a quick second. So her issue is she wanted an investigation. They said they did it. They refused or whatever. But what happens is when this other individual dies, she picks up the phone, first anonymously calls and gets a message to them, say, hey, you should be aware that in 22 this happened, but everyone figured out it was her who called.
Yeah, I think she sent an anonymous letter or email or some other, it was sort of a written
Yeah, she tried anonymously first to tell them, and then it became known who it was.
Right.
In any event, she wanted to understand that what happened in 23, she didn't view as an isolated event, and then she's, retaliated against. The interesting issue I have, so I read the complaint. In the first 20 or so paragraphs, I don't see any reference to being a whistleblower. You see Right. And I'm wondering because I didn't look at Virginia's whistleblowing statute, and maybe I missed it. But whistleblowing typically is telling a government agency, right? Or telling your employer about something happening. It's not telling a private third party
But
about,
she did. She reported it to the chief in her
right,
situation.
internally.
Then she complained about being retaliated against. But in particular, she cooperated with the Virginia, they call it VCOSH, but it's the Virginia's state OSHA, who was investigating the fatality. And shortly after the second actually the only fatality, shortly after the firefighter died in 2023, it's VOSH. I'm looking at it on the screen now. VOSH, Virginia Occupational Safety and Health Program. One of their investigators concluded that this was just an accident and that's all there is to it. And they weren't going to do a full investigation, at least according to the complaint,
Right.
and that she reached out to them anonymously and said, you need to look at this deeper. You need to understand that the same thing happened to someone a year ago. And she didn't identify.
That would definitely be covered by whistleblower.
And and I think that's the whistleblower connection right there. And she's also alleging that's a First Amendment as well.
Yeah, I don't know whether it is real. I've never thought of whistleblowing from a First Amendment. I mean, it is protected speech, but there's so many, there's, I don't know. It's interesting. In any event, this has remnants in New York State of the Watertown death. That's the first thing that occurred to me.
And I think that's where you and I discussed this. When was that? About a year ago, 2 years ago?
Yeah. Probably right in that range, about 2 years ago. And since then, there's been Attorney General investigations, OSHA investigations, criminal investigations, all saying nothing done wrong. But everyone distrusts the fact, look, in at least Watertown, it's a state fire academy. It's the state. You've got the state investigating, so people and state agencies investigating. So people
I've got 20 of these cases. This is not uncommon. Now, it might only be once or twice a year it happens, but when you look at it over the course of the last 20 to 30 years, this has happened in Jacksonville. I mean, we could just, list the various places where this has happened, and it's probably happened many places where people aren't even aware that rhabdo is a problem. Okay?
And look, I don't think
overexertion at rhabdo, it's all into one, and our instructors, well-intentioned, I'm not questioning their intention, but they've got to understand that you can't just push people like you see on Full Metal Jacket. You just can't do that. And there's individual instructor responsibility, and there's the people who are in charge of the fire academy that need to make sure that people understand this.
And look, we need opening and middle of day and ending vital signs and checks and hydration checks and all these different things.
Hydration and rest, absolutely.
Right. But normally what you get is, guys, if you're not, peeing whatever, then you're not drinking enough. And that's the only thing you ever hear people say, as opposed to let's check your blood pressure, your heart rate, all of this to make sure you're doing okay. Have you stopped sweating? Are you dehydrated? Are you hot? Are you too cold? I mean, we're not checking this stuff. We're just, hey, how is everybody? And nobody, especially a recruit, wants to say, I think I'm having an issue, and they may not even realize it.
Right.
Okay. In any event, interesting case. And it's not unique, but Cincinnati, this is a little unique. You have a Ohio firefighter who is facing firearm-related charges. I don't know anything whether he's going to claim self-defense or what, but
I'm assuming, but
on October 11th of 24, he's outside a bar at 2:30 a.m. Nothing good happens outside a bar at 2:30 a.m. Let's be clear. And according to the state prosecutors, there were 20 shots exchanged, not out of one gun, between him and another man. And the other guy was struck in the head. And then a woman, allegedly, who's an innocent bystander, was also struck in a car. These things are hectic, but in any event, at the moment he's on unpaid administrative leave, which I agree is the right way to do this while this investigation happens. He denies the charges, of course, but
I think it's a little curious, and I'm looking at it from the day-to-day fire department operations, but this happened, I guess, about a month. He gets arrested about a month after the shooting happened, but he got called in for an overtime shift. And then as he arrived at it, he was arrested. And
that was a setup.
That's what I'm saying. It seems a little curious that, hey, can you work overtime? Go to station 11 today, you know? And he ended up getting arrested. And I don't know. I'm not sure that I would really want to have my fingerprints on that particular decision right there, but
yeah, no. Just, I'm sure he has a house. Arrest him at his house. Don't get involved as the employer. That's no good reason to do that. But of course, it's the same issue with ketamine, as we'll talk about a little later. The EMTs want to assist the police. The firefighters want to assist the police. The fire departments want to assist the police. We're all one and the same. So sometimes we do things maybe we shouldn't do. I agree with you. I wouldn't have done that. Get him at his house. Okay, now speaking of ketamine,
and I would actually think you should be able to call a firefighter and say, look, we've got an arrest warrant. You and your attorney meet us at the courthouse, meet us at the police station, and there's no need to, do a full felony arrest on somebody like that.
The only thing they may say different is, well, we want to get a search warrant for his home, so we want to detain him at work while we search his home, but we don't want him to get rid of the gun. I'm making this shit up from TV. I have no idea.
I mean, I watched the video. I wasn't looking at facial recognition, but it seems to me he may be one of the characters that is holding the gun, and then you hear the shots going off. So
yeah. Okay. It's not about face. I got some emails from people that said, "Oh, why in Aurora, with the EMT and the paramedic firefighter, how could he, reverse his decision if there were statutory minimums?" Let me explain what happened. So the medic, who is apparently the most severe of the charges and convictions, the medic who administered ketamine, who claims that he didn't know really the weight of the patient. He gave a lot. He didn't have time. It was an urgent situation. So he gave two times or whatever, but I was going to get physician approval for it. I just didn't have time, and I was going to get it after the fact, but I didn't have time. All these things. In any event, he was sentenced for his crime to the statutory minimum. But so that's not been reduced. That wasn't reduced. But a statutory minimum says for this charge, for this crime, if you're guilty, the judge has no discretion but to sentence you to this, right? And he was sentenced to concurrent sentences. I mean, was it concurrent or it was concurrent?
Yeah, they were concurrent, yeah.
Yeah, so they run at the same time. So if you got 3 years for this and 3 years for that, it could be 6 years, but concurrent is, they run at the same time. So in any event, what happens is he served a certain number of days, almost 200 days in prison, I think, 100 some odd days. And at that point, if all is good, the judge has the ability to release them and put them on probation. I don't know this, but I think this is a lot of prosecutors and judges do not like mandatory minimums. It came out probably 20 years ago.
The only people that I know that like mandatory minimums are elected officials running for office.
Right.
Who think that that's going to help them get elected.
Right. And that's where the cocaine discrimination came from versus marijuana. That's where all these things, and they're racially biased. There's no question. It's not my comment. It's proven these are racially biased. Even though it takes discretion away, the charges upon which they're based sometimes aren't always fair. In any event, they didn't reverse anything. He was sentenced for the mandatory sentence, but the judge, who recognized that the EMT was more of a model EMT than he was a bad guy. And there's a phrase in what you quote, which I thought was interesting. What the judge says is that he has a prior, quote, pro-social history. I'm presuming what he meant, though I have no idea, is that he was, very pro-African-American, wasn't racist, and apparently was vocal about it, so that this probably was not a hate-based attempt or race-based attempt to cause injury. It was, I'm just trying to help the police, and I really thought I was doing the right thing.
Yeah, I think the alternative to pro-social is anti-social. So, and I think that the judge is basically saying that this person he's not your typical criminal. He's not anti-social. He wasn't out to hurt anyone, or he's not oblivious to the pain that resulted from this to the person's family. That there was no, what we typically think of as criminal intent in this. And that's kind of gets back to my take on this, is that he should not have been convicted in the first place, that
No.
there should have been civil consequences.
He
There may
was
have been
negligent.
some,
He was
right,
negligent.
right, absolutely. There should have been civil consequences, and certainly administrative consequences in terms of his EMS license and
Yep.
departmental issues there. But this, to me, this is this should not have gone criminal. I think it's a shame that it did.
Yeah, I was shocked he was convicted
Yeah.
because the conviction infers some sort of intent to harm, right? There has to be what's called mens rea,
It's
the
terrible.
intent.
It's feeding into a societal narrative that just is not, it's not healthy for us to have that that narrative in the first place. And as applied in this case, it just, I think it's terrible.
Right. Agreed. Agreed. And the IFF came out in favor of support of him. And of course, the prosecutor was against him, but it is as it is. But look, the guy's got a felony record. What's he going to do in his life anymore?
Yeah.
It's not probably not going to work anymore. So, okay. Lastly, speaking of felony records, this is horrible. We have two FDNY chiefs. I'll kind of give the lay of the land here. They've been indicted now on bribery charges. I'm guessing perjury is coming next. But they've been indicted on bribery charges. And basically what happens, these are two chiefs. They're in charge of like the code division, for lack of better words, and approving property and permits. And it's a process to get through it. And then what happens is another firefighter starts this business where he said, well, I can get you priority in your review, even though it's supposed to be in the order they came from, and pays these chiefs almost $200,000. I think it was 190 or something, $190,000 in payments to basically, they're bribes, right? These are bribes. And hey, if you move these up in order and you just approve them, even if they shouldn't be approved, right? Then that's what's happened.
A lot of times
apparently,
people think bribery is taking money for example, approving the plans without actually making sure they comply or looking the other way at violations. And certainly that is bribery, but also moving them up on the calendar
right.
is also bribery.
And look, there's a code of ethics and a code of conduct in the FDNY. And I'm positive one of the things it says is you're not going to accept money to perform your duties right. So it's just a bad, anyway, it shouldn't have happened. I always hate seeing this stuff in the fire service.
I got some folks from FDNY that reached out and they were shocked. They were absolutely shocked that something like this was going on. Stuff like this may have been going on in law enforcement back in the Serpico days, and maybe some of it may still be going on on NYPD, but not in FDNY. One would hope, and I know that the folks who reach out to me were very passionate that this is an isolated situation, that this is not something that is a big concern or a big major problem in FDNY.
Look, thank God, the allegation, I believe, is not you allowed some unsafe things to happen.
Right.
Right. Thank God, because then.
And I think that can be how people rationalize it. They're saying, well, we really didn't jeopardize anybody. All we did was we moved them up on the priority list, and that's how they rationalize it to themselves. But it still is a bribery, still is a problem. Yeah.
If you're changing the way you're required to act and you're doing so for money, that is bribery. There is just no other way around it. Well, is that 5? That is it for today.
That's 5. Yeah. We get through them on 30 minutes. That's excellent. So
go us. Well, we're going to have an exciting week next week, starting in about 15 minutes. I won't say what it is to tease the viewers, but I'm going to be filing what I think is going to be a huge lawsuit, which I hope and believe goes to the state's highest court to resolve this, and could even go back to the United States Supreme Court. Well, potentially.
Maybe since we have a minute or so, maybe you're not talking about your case yet. But let's talk about the lay of the land and the recent, you were telling me about it. It's something, I tend not to read cases if they don't involve fire departments. I know you kind of take a broader scope at this, but apparently there was a U.S. Supreme Court case on an SEC case.
Yeah. So what happens is the Securities and Exchange Commission, a federal agency, fines this guy Jarkessi $300,000 for fraud. Now that's very important. And he says, listen, this is unfair. And I say this all the time, by the way. I hey, I try cases in front of administrative agencies almost every other week. I'm very busy in front of like Department of Health, different offices, but all the state and some federal administrative agencies. And the problem with it is, let me say this. One, there's no jury. There's a judge who maybe is a lawyer, but is not a practicing trial lawyer. Two, there are no rules of evidence. So hearsay, which is, well, I investigated this and I talked to that person who talked to that person, and here's what I learned, and this is what I believe, that kind of BS is admissible, which is not right, right? Hearsay, well, rules of evidence exist to make sure that the evidence you put is authentic and reliable and accurate and not falsified in any way, right? Like a picture is a picture and hasn't been falsified. So, or somebody who said something actually said something, not, oh, I heard them say that they said. So those rules don't exist in administrative agencies. And the burden of proof is basically 1%. If 1% of the evidence is in their favor, but 99% of it's in my favor, the accused, the 1% that's in the government's favor can win the day. It's right. It doesn't matter. It's called a substantial evidence. It's not a majority of the evidence. It's just there's enough to prove it. And that can be very low. So what the United States Supreme Court did is say, you know what? If you're being fined with a civil monetary penalty, which is designed to punish the person doing it, that's step one. And step two is if what you're being charged with is something that a private person could sue you for, in this case, it's fraud, then based on those two factors, the U.S. Supreme Court said you have the right under the 7th Amendment to a jury trial because you're basically being charged like anybody else who would sue you. And so they came out and said, you have the right to a jury trial. So I said on a prior show, I'll give a little heads up in a second, that I think this applies to state agencies where the same tests apply, where there's a civil monetary penalty, which is designed to punish, step one, and step two, where there is something that a normal citizen could sue on, right? That's step two. Then you have the right to a jury trial. And I have a number of cases where I defend EMTs before the Department of Health. And I constantly say, you can't allow double hearsay. You can't allow triple hearsay. He said. I said, this is unfair. And the judges, they don't care, right? It's their rules. And by the way, the judges are in the same agency, right? So like if you're in front of the Department of Health, they're a Department of Health judge, and the Department of Health is bringing the charges against you. It is incredibly unfair, but this is true with the EEOC, all the federal agencies. So there's 29 cases who have now cited this U.S. Supreme Court case, which was only a couple of months ago. And they're talking about, there's one on the NLRB that said, nah, that's not applicable, but there are others, one that's OSHA that may be applicable. That's where I think I'm going to have one. But anyway, I'm the first case in the nation that I've seen so far that is saying, based on the U.S. Supreme Court case, and New York State, probably every other state, has a right to a jury trial constitutional provision in New York's Article 1, Section 2 of the Constitution, which says the right to a jury trial is inviolate, meaning there are no exceptions, right? It's critical. So I'm saying 7th Amendment, New York Constitution, same thing. We have the right. I predict, I've never had a case go to the U.S. Supreme Court before, but I'm betting this could get there. Certainly to the state's highest court, but this is going to turn, if I'm right, big if, we'll see what the Attorney General says. But this could turn administrative agency proceedings on their head, but for the protection of the accused, right? We're protecting the accused, be it firefighter or anything else. We're protecting the accused, and that's what should happen here. So as soon as we disconnect here, I'm off to file it, and then I'm sure you'll post it because I'll send it to you.
I will. So yeah, it's a fascinating issue. Hopefully everyone followed it. I know it might the legal eagles out there are going to follow what you said. So if not, come back next week because we're going to be talking about the actual suit that Brad will be filing this afternoon. So all right, man. Well, that'll do it for another edition of Fire Law Roundup. Thank you everyone for watching. Please click like and